So welcome everybody to this webinar on COVID immigration implications. And COVID has changed every aspect of businesses in Scotland and the UK, and immigration is one of those areas that's impacted along with others. And this webinar is part of a series of webinars which Brodie's are running on COVID implications for businesses. So do take a look at our COVID hub, which has got more information and FAQs and other webinars that we're running. So before I get into the detail of what we're going to cover today, I thought I'd just start with some housekeeping issues. So the session today is about 30 minutes long. We're going to talk for about 20 odd minutes of that, and then there'll be some time for questions and answers at the end. Everybody's on mute today just to avoid interference with the line, but you can ask questions throughout using the Q&A function, which you should be able to see on your screen, and those questions will just come through to us, so so don't worry about anyone else seeing them. You can put your name on or not, that's up to you. And you can also use the chat function if you've got any questions about technical issues or anything else as we go. We are recording the session today, so we'll circulate copies of that later, and you'll also get copies of the slides, so you don't need to take notes. And there'll be two speakers today. So for those of you who don't know, I'm one of the partners in the employment and immigration team at Brodie's, Elaine McIlroy, and I'm also going to be introducing one of my colleagues in a moment, Erin McLafferty, who's going to be delivering the session with me, who you can see up there. So in terms of what we're going to cover today, I guess there have been a number of special measures introduced by UK Visas and Immigration to respond to the COVID crisis, and we thought it'd be helpful to update you on all of those. And what I would say is a lot of these measures are changing very quickly, so I would keep an eye out, and we'll be providing more updates on things as they do change, because we've seen on almost a daily basis UK Visas and Immigration introducing new guidance in this area. So we're going to cover right to work checks and how to do those in light of the COVID crisis, changes to notification requirements for Tier 2 migrants who are working at home as a result of COVID. Erin's going to touch on a new extension process for visas to avoid those who are stuck in the UK from overstaying. So there's a new process in place that she'll explain. I'm then going to talk about visa extensions for longer term visas for people who plan to stay in the UK, and some of the changes to the rules on switching in the UK. I'll talk a little bit about furloughing tier 2 employees and some other measures that we've been advising clients on recently. And then we'll finish off by touching on the settlement scheme and the future points-based system and the way in which those have been impacted by COVID. So I'll hand over now to Erin, who is going to start off.
Hi everyone. So as Elaine mentioned, I'm going to start off by talking about right to work checks and how to carry them out during the COVID-19 crisis. Right to work checks continue to be necessary during the crisis. However, checks have been temporarily adjusted to make it easier for employers to carry them out while employees may not actually be in offices and may not be meeting with new recruits in the way they normally would. So it's important to note that these checks do continue to be necessary, and it is still an offence to employ anyone that doesn't have a right to work in the UK. If a right to work check is not carried out in line with the UK guidance, including the new COVID-19 adjustments, then you will not have a statutory excuse if you're found to have employed an illegal worker. So the new guidance came into effect on the 30th of March 2020, and under these temporary measures you would conduct a check slightly differently. So when conducting a check, you would firstly have the worker submit a copy of the original document to you electronically, so either via email or via an app, and you would then have a video call with them. And during that call, you would confirm their identity and ask them to hold up the document that they've sent you a picture of on the call, and you would do a check to ensure that the document that they are showing you matches with the one that they've sent you a picture of. You would then make a record of the date on which you've done that, and you would note just that you've done an adjusted check and the date was undertaken, and that the fact it was done like this due to COVID-19. If you have any new recruits or anyone you're doing a follow-up check for who has a biometric residence permit, a biometric residence card, or any kind of status under the settlement scheme, you should use the online checking service, which has been enforced for about a year now, and you should do that on the call, on a video call, confirm their identity, and you should bring up the information on the call as well to check they have the right to do the work you're requiring them to do. Some applicants may not have original documentation at the moment. Due to COVID-19 closures, some application centres have had to shut without much notice, and some people's documents have been retained by Home Office processing centres. So that means not everyone will have access to a document. If that is the case and the person you're wishing to recruit or doing a follow-up check on doesn't have a document, you should use the employer checking service in the normal way. The guidance in relation to that hasn't changed, and the full guidance can be found in the government's Right to Work guidance document. After the measures that have been put in place come to an end, there will be a need to conduct a retrospective check. So once the government say these measures are now finished and we will not conduct right to work checks like this, you will have an 8-week window to undertake a right to work check in the normal way. And you should ensure that you do it in line with the current guidance and ensure that you are satisfied that they have a right to work in the UK. This differs slightly from the previous rules. Under the previous rules for checking a right to work, you could use a video call, but only to confirm someone's identity. This has been loosened slightly to recognise that it may be more difficult to access original documents, but hopefully any issues should be flushed out with a retrospective check. An employer should ensure that they're diarising ahead just to check that the measures have not come to an end, and to ensure that once they are, they have a reminder in place to conduct the follow-up check, which is required to gain the statutory excuse for that worker. Next, I'm going to talk about reporting obligations. So for those of you that are sponsored or licensed sponsors, you will be aware that for migrant workers, there's a whole host of things that you have to report on in relation to that migrant worker. So things like change of place of work or change the job title or salary. However, COVID-19 is having a really big impact on how the UK workforce is working. So we have a massive increase in people working from home, and we are expecting a big surge in absences from work relating to the virus. So the government have released some guidance in relation to this, just to clarify what needs to be reported and when. The new guidance relates to home working, and normally it is a requirement to report where there's a change of place of work for a migrant worker. So for example, if you have someone who works at office A and you're moving to office B, that would normally be reportable. However, during the COVID crisis, you're not required to report any migrant worker who's working from home, so long as that home working is temporary and as a result of COVID-19. Permanent changes to place of work continue to be reportable and should be reported in the normal way, and any changes to job title, salary or duties should also continue to be reported. It's also important to make sure your level 1 users continue to have access to the SMS if they're working from home, just so that they can report anything that has to be done. Also, in terms of absences, under the current rules, anyone who is absent from work for a period of 4 weeks and are unpaid for any reason other than maternity, paternity or long-term sick leave have to be reported to UKVI, and the sponsor usually has to cease sponsorship of that individual. However, in light of an increase of absences in work related to COVID, the government have eased that requirement slightly, and anyone who's absent from work in relation to COVID do not need to report, and you do not necessarily have to cease sponsorship. So for example, if you have someone who's absent from work because they have childcare issues, given that a lot of schools and nurseries are currently closed in relation to the pandemic, that would normally require to be reported, but the government have confirmed if it's COVID related, you do not have to report that. I'll also quickly talk about the new temporary visa extension processes that are in place. So there are lots of migrants in the UK currently who have visas that are due to expire over the next few months. And there was a bit of concern about these individuals and what they would do if they could not leave the UK as planned because of either periods of self-isolation in relation to the virus, or because there are travel restrictions in relation to their home country. The government have confirmed that for those who have visas that are due to expire, and importantly were due to leave the UK, at the end of that expiry, they can apply to have an extension. This will only impact a narrow branch of migrants. It will only include people, for example, that are business visitors or visitors or those who have, for example, Tier 5 youth mobility working holiday visas. So it's important for employers to do an audit of their workforce and to identify anyone they may have either visiting their organisation in the UK or working for them in the UK that may fall under that bracket. If they have anyone on these types of visas and the visas are due to expire between now and the 31st of May 2020, they should get in touch with them and check what they are doing in relation to leaving the UK or whether they need to apply for an extension. Such individuals, if they cannot leave the UK because there's travel restrictions or because they are self-isolating, they can apply for an extension. And as an employer, there's nothing you necessarily need to do in relation to that, but it's important for you to know where to find that information, which is all on the government website, and that you can direct the employee or visitor to the particular pages on the guidance and the application form itself. If individuals cannot leave the UK and don't leave the UK and don't apply for an extension, they may be classed as an overstayer, and that can then lead to issues on re-entry to the UK in the future. So if you have a business visitor who visits the UK very regularly for training or for meetings, it's important for them to ensure they follow the right process, because if they become an overstayer, it could impact their ability to visit the UK in the future. So I'll quickly show you the application form, which is quite short, and that is unusual for UKVI, but the application form is on the screen. There's not a lot you have to do as an employer. It's all mainly factual, and the individual, the employee or the visitor should complete it themselves. They should have all the information to hand. The Home Office recommend that the individual takes a screenshot and that they ensure their email address is correct, because all correspondence in relation to this will be via the email address input. So they will get confirmation within 5 working days to that email address that their extension has been granted. For those that you employ under Tier 5 visas that may be due to expire, you would also want to ensure that they continue to have a right to work in the UK. So for those individuals, you would want to double check that they make this application, that they make it in time, which means before their visa expires, because that then provides you as an employer with a grace period during which you can go to the employer checking service and seek a positive verification notice, which allows you to continue employing them and have a statutory excuse in relation to that worker. The initial grace period is 28 days, so you have that 28-day window, but it's only if the application is made in time. And if there's any uncertainty about that, we always recommend you take advice or double check the guidance on it. And the same with visitors, just ensure that they have the correct permissions to be here and they are not being classed as an overstayer. I'll now pass on to Elaine, who will talk about those who have visas due to expire and will be extending.
Thanks, Erin. So I'm going to talk about 3 other special measures which are in place on a temporary basis to deal with COVID. So the first is for those individuals who would need to extend their visa in the ordinary course. So as an employer, you might want to do a check or an audit to see whose visas are coming up for expiry in the current months, and to think about what process can be followed to make sure that they can make the applications that they need to. So for those individuals, because these UK visa application centres are currently closed, it means people can't attend to get their biometric information taken, and they can't submit documents in the normal way. So UK Visas and Immigration have said that those individuals should make an online application in the usual way, so they should complete the form. They won't then be able to go through and attend for a biometrics appointment, and they won't be able to complete the rest of their application. But provided that they do that first part, the online application, and provided they do it in time, which means before their current visa expires, then their current visa conditions will continue on an interim basis, meaning they can continue to stay and work legally, pending things coming back to normal, and then being able to finish off and complete the submission of their visa application, at which point in time they'll then be able to document to their employers that they have got their visa decision through. In the meantime, employers can carry out checks to ensure those individuals have the right to work using the employer's checking service, and they should be able to get a positive verification notice to give them a statutory excuse on that interim basis. And then when things resume and become normal again, those individuals will be able to finish off the process. The second special measure which I wanted to mention is that there's been a change to the rules on switching, and by that I guess these rules deal with who can switch from one immigration category to another whilst staying in the UK. Normally if you're here in the UK on a temporary visa, so that might be a tier 5 temporary visa or a visitor visa or whatever, you would have to leave the UK, go back to where you come from. For example, if you're an Australian, you would go back to Australia, and then you would make an application to come back to the UK if you want to do so in a more permanent immigration category. So for example, if you wanted to switch from tier 5 into tier 2 general, you would go back home, make an application, and then come back in. That's obviously not feasible at the moment because of travel restrictions due to COVID, etc. So they have made a special concession which is in place until the 31st of May 2020, but I would say watch this space because that time period or that time scale may be extended. But those individuals can currently switch whilst in the UK, so they don't need to leave and come back, which is pretty useful for people who are not able to travel right now. The criteria for applying for the various visas are the same and the fees are the same, but that special concession will make a difference for folk and who are obviously not able to travel and leave and come back in. And then the third special measure I just wanted to mention, it's more niche, it doesn't apply to everybody, but you'll have probably read about it in the press. So the government has said for those working for the NHS as doctors, nurses or paramedics who are on a tier 2 visa, they'll get an automatic extension of a period of a year if their visas were due to expire before the 1st of October 2020. That also applies to their family members. So some employers might have family members working for them who are impacted by those changes, and that's at no cost. And they're going to be in contact with the NHS employers in order to facilitate those arrangements. So that's one less thing to worry about for them for now, which is good. I want to move on now to talk about furloughing tier 2 employees. We have been very busy advising lots of clients about furloughing for the past few weeks, as have employment teams all across the UK. And some of the questions we've been having have related to people in tier 2 visas. So I thought I'd just touch on that. So the latest guidance that we have on the job retention scheme, the furlough scheme, has made it clear that if an individual on a tier 2 visa receives funds indirectly through the government through that scheme, that won't breach their visa conditions. So normally if you're in the UK on a visa, you don't have recourse to public funds, you can't claim benefits, etc. But they've said that receiving funds under the furlough scheme is okay, so you can potentially furlough your tier 2 workers. But we've had some recent guidance, I guess, making it clear in what circumstances tier 2 people can receive temporary pay cuts. And normally if you're furloughing somebody, that involves a temporary pay cut. And the guidance is a little bit different from UK visas and immigration than is described in the furlough guidance itself. And it talks about a temporary pay cut being possible in circumstances where the employer cannot pay the tier 2 worker as a result of a temporary reduction or cessation in trading. So that test is different than the furlough guidance, which talks about the employer being severely impacted by COVID and not being able to maintain its current workforce as a result of COVID. So I would say the UKVI guidance is more restrictive on that in terms of when you could give a tier 2 employee a pay cut with their consent. So the guidance we've had does say it is possible, but in those more limited circumstances. And I would say if you're thinking of doing that, do take advice. It may be that the speed at which things have been going has just meant that it's described a bit differently in each of the guidance notes, so that could be revised in due course, but for now it does look as though it's a bit different. And other restrictions are in place so that the employer must show if they're going to furlough a tier 2 worker or reduce their salary on a temporary basis, that any reduction is part of a company-wide policy to avoid redundancies, so that's an added requirement. And also that the reductions are temporary and that the employee's pay will go back to its previous levels after these measures are no longer in place, and that all workers are treated the same. So that means not just furloughing tier 2 workers, for example, there must be a consistent policy that's applied across the board. But if you follow that guidance, it appears that you can pay below the normal salary thresholds that would apply to tier 2 workers. and it also means that you can apply below the job code sort of minimum salary levels. So that is a special concession under the rules that wouldn't normally be in place. But it means you can potentially furlough tier 2 workers. Some added considerations to bear in mind if you're doing that are you would need to make sure that the furlough letter is added to their HR file, because you've got record keeping obligations in relation to your tier 2 workers. And you would have to also make sure that any changes to salary and the fact that they are furloughed is reported through the sponsor management system. And it's also worth bearing in mind that those furloughed workers won't have access to the same benefits as other people, and they also don't have the same flexibility to take up other jobs as other people, because there are restrictions on tier 2 employees taking up second jobs, which some people who are furloughed have been doing. So some relevant differences there to bear in mind. I'm now going to touch on some other measures that we've been advising clients about in addition to furlough. So the first of those is the pay cuts, I guess more permanent pay cuts rather than temporary ones, which furlough relates to. So in theory, it is possible to agree a permanent pay cut with a tier 2 employee. If you do that, the previous guidance that I talked about wouldn't be relevant, because that only applies to temporary pay cuts. And you would therefore need to make sure that any reduction in salary still meets the minimum requirements under the sponsorship rules. So minimum salary thresholds, the minimum salary applicable to the job code. But if you're already paying someone more than that minimum, there may be flexibility to agree a pay cut with them. That also would still need to be reported through the sponsor management system so that UKVI is aware of what you're paying them. And it's also worth bearing in mind that there are certain limited cases where people's pay can drop below the sort of minimum salary. So for example, sick leave, maternity leave, etc. And one exception that we have been advising clients on is for tier 2 intra-company migrants who are going to be outside of the UK for a period. So we've had some clients send people back to their head offices, I guess, for a few months whilst the COVID crisis kind of unfolds. And those individuals who are spending time outside the UK don't need to meet the minimum salary thresholds during that period. So we're an area worth taking advice on though, because there's quite a lot of exceptions and complexities to that. Cutting hours, also possible, usually has an impact on pay, so you need to think about the pay cut implications of that. And also worth mentioning that those in the shortage occupation list have to do a minimum of 30 hours a week. So if you were considering cutting hours and pay for a migrant worker who's sponsored, bear in mind that minimum. Special rules for new recruits is one of the points of my slide there. So UK Visas and Immigration have said that because of the interruption to kind of visa processing, it will be possible for employers to have tier 2 employees start work with them even if their visa has not been completely processed, which is quite a significant exception to the normal rules. So what they've said is if you've already assigned a certificate of sponsorship to somebody to start in a new job, provided that they do start in that job that the certificate of sponsorship relates to, and provided that they've made their online application, even if they haven't been to do their biometrics and the decision has not yet been given to them that they've got their visa, they can start working for you as an employer on a kind of temporary basis. And you as the employer will be responsible for them in terms of sponsorship duties from the point where they start work, even if they're not showing up properly on the online sponsor management system. But that's an important concession to avoid people being sort of stuck and not able to start their new jobs because of the interruption to the visa processing services. So that's worth bearing in mind. And I think there's similar measures in place to allow students to also sort of start. So if you need more advice on that, yeah, do just check the rules. Certificates of sponsorship, yeah, there's been some easing off on the sort of strict timescales relating to that. So if somebody has had a certificate of sponsorship but has not been able to apply for their visa and then entered the UK in the normal timescales, then they've said they're not automatically going to refuse visa applications just because they haven't stuck to those sort of rigid timescales, which is good news. Right, so I'm now going to touch on the settlement scheme. We've had some questions through from clients saying, is it still all happening? Is Brexit happening in the background because everybody's turned all of their attention to COVID for a period of time? And yes, it is still there in the background. It remains open for applications. They're not up to full speed in terms of processing applications in the normal way. So, for example, they're not manning the telephone lines. You still can make email inquiries. People can still apply using the app if they can certify their ID using the kind of mobile apps. But for those who were having to go to sort of document scanning centres to have their ID verified, those are shut just now, so that's not possible. And for those who were having to submit paperwork by post, those are not getting processed in the same way. So we've not yet had the stats through for how many applications they had in the month of March, but my expectation is that that will have dropped a lot as people's attention has drifted from that and focused on the lockdown and COVID for now. And I suppose the main message for employers is that at the moment the transition period is still due to end at the end of December this year. The government said it's not going to ask for an extension so far, although we don't know if that will change or not. Therefore, people do still need to be in the UK in order to be eligible for the settlement scheme before the end of the year. Some employers had planned to bring in new recruits before that deadline if they anticipated future recruitment shortages. So it's worth bearing in mind the implications of COVID on that. That might be more difficult to get people in before the end of the year to be eligible for the scheme. People will be able to apply through the scheme up until June 2021. So if we see an easing of restrictions and things, I expect people will get back into sort of making more applications. And from the employer's perspective, I guess the sooner the better in terms of when people can make those applications and get their paperwork in place, so that there isn't a risk of them getting refused or rejected towards the end of the period and not having time to reapply, for example. So I expect after the immediate impact of COVID sort of subsides a bit, that people will maybe turn their attention back to that. And just a point on absences very quickly, to say that if you have employees locked out of the UK, stuck in a different country, anyone who has an absence of more than 6 months in the period of any 12-month period under the settlement scheme may lose their right to get settled status under the current rules. So worth getting people back into the UK when you can, if that is likely to be a possible issue. And the government might slacken off that rule in the future, but for now that still remains a restriction. And then finally, on the future points-based system, it was announced last week. I guess further guidance came from the government about that still coming into place on the 1st of January as planned, despite COVID. It's going to be open for applications from the autumn, which isn't very far away. They have changed the rules on who can apply for a licence, so employers who have just medium skilled as well as high skilled jobs can now apply for licences, and they're saying it will take them 8 weeks to process applications from the receipt of paperwork on those. So I would say, again, it's not everybody's immediate priority because of COVID, but if it's going to take them 8 weeks, and actually they may well have backlogs and things when they get to a sort of fully functioning status again, then it's worth just making sure, if you don't have a licence already, to get one in place. I guess by the summertime would make sense rather than waiting any longer for that. So we're going to just briefly, I know we're almost up to our half hour, but deal with a couple of questions. Erin, have you got any questions coming through?
Yeah, so I have one here. The question is, we are in the process of furloughing staff and we have a few tier 2 workers who we already furloughed. We haven't yet reported this to UKVI. Can we do this now? And if so, what do we need to tell them?
So if anyone has gone ahead and furloughed tier 2 workers, I guess without being aware of the reporting requirements, normally reports on things like changes of salary would have to be done within 10 working days of the change. But if you haven't done that, I would just say do it as soon as you can. And it's likely that UKVI will be understanding, I guess, about COVID implications and not too strict, hopefully, on those reporting restrictions. What needs to be reported would be any changes to, I guess, the fact that the person wouldn't be attending work, that they are furloughed, that their salary has changed. And as I said in the session, I guess a copy of their up-to-date contract of employment, including any amendments made to that, should be kept on their HR files. And I would also then double check that what you've done is compliant with the rules in terms of the policy guidance that I described earlier. Are there any other questions? Maybe
yeah.
just time for one more, possibly.
Yeah, so we are looking at various options, including restructuring, and it is possible that we may need to look at redundancies, some of which may impact sponsored staff. If we have alternative roles to offer, can they do that under their current visa, and what if there's a salary job attached to the new job?
So redundancy, so if somebody's role terminated altogether, that would result in the termination of their sponsorship, and that is something that would need to be reported to UK Visas and Immigration, and that person's leave would eventually be curtailed. If their current role is potentially redundant, but you have an alternative role available for them to do, you need to check whether the alternative role is in the same job code as they're currently sponsored to do. If it is, it should be pretty straightforward to just report any changes to their salary or job description and job title, etc., through the sponsor management system. What would be a more significant or difficult change to deal with would be if the new role is in a different job code, because that may result in a resident labour market test having to be carried out before they can start in that alternative job. So I would say in that scenario where it's a brand new job code, yeah, take advice, because you may have to go through a process before you can just slot them into a new job. And I would say in big scale restructuring exercises, sometimes the immigration implications can be forgotten about a little bit because everybody's busy with everything else. So flagging up that tier 2 workers may have special restrictions attached to them is worth sort of thinking about at the outset, because it may impact things like timing. Well, thanks everybody for joining. We've just gone past 12:30, so I will draw the session to a close, but if you do have other questions, please do use the Q&A boxes, and we can hopefully come back to you separately on any questions that you've got, or feel free to drop us an email. My email address is up on the screen just now if you've got any questions following up. Thank you very much.
Thank you.